Hi everyone. I wanted to publish this midweek recap of recent BIA and Federal Circuit Court decisions and their relationship to Supreme Court cases that are in the news, in particular about the stop time rule for those in removal proceedings, and discussing general issues with the immigration court system with immigration attorney Sabrina Damast. Welcome to the Immigration Lawyers Podcast. I am the host, attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Sabrina, thank you so much for coming on. There's been some, changes and some big deal kind of stuff going on. So what's going on with these big cases that are happening with, Supreme Court and Ninth Circuit and all that?
Well, it's been a big couple of weeks on the issue of the stop time rule for both cancellation of removal for lawful permanent residents and cancellation of removal for non-lawful permanent residents. So I'm going to talk about the lawful permanent resident case first. The Supreme Court granted certiorari in a case out of the 11th Circuit called Barton versus U.S. Attorney General. And they did that because there's a circuit split on this issue. For example, the 9th Circuit has the opposite outcome of what happened in Barton at the 11th Circuit. So to give you a little context, there's three major requirements for cancellation of removal for lawful permanent residents. One is that the person not have been convicted of an aggravated felony. The second is that they have been a lawful permanent resident for at least 5 years. And then the third, and that's the more complicated one and the one that's the subject of the case, is that they have been present in the United States for at least 7 years pursuant to an admission in any status. That 7 years can stop accruing because of a couple of different events. One of them is service of a notice to appear on the person that initiates the removal proceedings. That stops the time of accruing on the 7 years. But the other thing is certain types of criminal convictions. And those criminal convictions are divided up into two different categories for the purposes of what we call the stop time rule. One are convictions that render you inadmissible, and one are convictions that render you deportable. So typically speaking, when you're a lawful permanent resident, you're really only worried about deportable offenses and not inadmissible offenses. And the exception to that is when lawful permanent residents are returning from trips abroad. When they're returning from a trip abroad, then they could also be held accountable for any grounds of inadmissibility that they've triggered, including criminal ones. And that's where the circuit split has developed here. Between the 9th and the 11th on this issue. And the issue is whether, for the purposes of the stop time rule, you can hold a lawful permanent resident to have stopped accruing the required 7 years because of an offense that would render them inadmissible when they're not returning from a trip abroad. So the 9th Circuit said no, unless a lawful permanent resident is returning from a trip abroad, we're only looking at the criminal grounds of deportability that would trigger the stop time rule when we're measuring whether or not the lawful permanent resident has the required 7 years. But the 11th Circuit said, hey, no, not so fast, right? The language of the statute talks about both inadmissible and deportable offenses. And we think in this context that lawful permanent residents can have a stop time rule trigger if they have an inadmissible offense, even if they're not returning from a trip abroad. So the Supreme Court granted certiorari in this case. They're going to resolve this circuit split as to whether or not a lawful permanent resident who is not returning from a trip abroad can suffer stop time rule consequences for a conviction that only renders them inadmissible, but not deportable. And that's basically where we stand on the Barton case. So then we have the 9th Circuit today, or actually not today, but earlier this week on the 22nd, issuing a decision in Lorenzo, Lopez versus Barr. And this is also a great decision involving the stop time rule. And although it involved an individual who was applying for lawful permanent resident cancellation, it has equal force for people who are also applying for non-lawful permanent resident cancellation. But let me take you back to last summer when the Supreme Court issued its decision in Periera versus Sessions, because that is where this case is born, the Lorenzo Lopez case. So as I mentioned earlier when we were talking about the Barton case out of the 11th Circuit, the accrual of the 7 years that are needed after an admission for lawful permanent resident cancellation can be stopped by service of a notice to appear. The notice to appear being the charging document in an immigration court. Now, in Periera, the person was actually seeking non-lawful permanent resident cancellation, which has, amongst other things, a requirement that the person be physically present in the United States for at least 10 years. And again, those 10 years would stop accruing upon service of a notice to appear. Now, Periera said, the Immigration and Nationality Act has a very specific definition of a notice to appear. And that definition requires that the notice to appear state the time, date, and location of the first hearing in a case. Now, John, I know you don't do removal defense, so I hope you'll take my word for it. But none of the notices to appear that I've seen in 8 years, except maybe about 3 that all were issued after the Periera decision, had a time and date on them. They just said to be determined or to be set. And the reason for that is that a notice to appear is issued by the Department of Homeland Security. The immigration court, however, is under the jurisdiction of the Department of Justice. So practically speaking, what's been happening is the Department of Homeland Security issues a notice to appear to the individual. They file it in the immigration court, and then the immigration court, which, as I said, is part of the Department of Justice, goes into their own calendaring system and decides when that hearing will be. And they subsequently issue a notice of hearing to the individual telling them exactly when and where they have a court hearing. So the petitioner in Periera said, look, I don't care who schedules what. The definition of a notice to appear is a document that includes the time, date, and location of a first hearing. And if you give me a document without that information, it's not a notice to appear that is sufficient to trigger that stop time rule. I kept accruing my required 10 years even after I got that notice to appear. The Supreme Court agreed with him. But what was left open and then subsequently taken up a few months ago by the Board of Immigration Appeals was the question of what happens after the immigration court issues that notice of hearing. Does the immigration court's issuance of a notice of hearing complete the notice to appear and trigger the stop time rule? And the BIA just a few days ago also actually, May 22nd, it's amazing how the BIA and the Ninth Circuit come out with things so closely in time with one another. No, I'm sorry, I'm looking at the wrong case. The BIA's decision was May 1st, so it was about 3 weeks ago, came out and said, we think that the issuance of that notice of hearing completes the notice to appear and triggers the stop time rule. Well, I have to tell you, there was a great number of immigration lawyers up in arms after this decision was issued on May 1st, saying that how could the Board of Immigration Appeals possibly come to this conclusion when it seems like the Supreme Court had already discussed the idea that you can't use a two-step process of issuing a notice to appear and then issuing a notice of hearing thereafter. So it turns out that the immigration bar would be vindicated yesterday by the Ninth Circuit when they issued this decision in Lorenzo Lopez versus Barr and said, absolutely, that the Periera decision stands for the proposition that you cannot use a defective notice to appear and then add on to it sometime later a notice of hearing and say that the stop time rule is triggered. So Lorenzo was an applicant for cancellation of removal for lawful permanent residence. He did not have 7 years after an admission in any status before he received his notice to appear. But his notice to appear, just like Periera's, was missing the time and date information for his first hearing. Unfortunately, unlike Periera, who had actually accrued his 10 years before the notice of hearing was sent out to him, the Lorenzo had not. So not only did he not have his required 7 years at the time of the notice to appear, but he didn't have it at the time of the notice of hearing. And so the agency found him ineligible for cancellation of removal on that ground. But the Ninth Circuit said, no, there is no completing the notice to appear through the second step of issuing a notice of hearing. The notice to appear remains defective. The stop time rule is not triggered. Lorenzo continues to accrue his 7 years. So we won a bit of a victory at the Ninth Circuit over the board this week, which is always a nice thing. It's a nice feeling for us in the removal defense bar to have the circuit courts remind the Board of Immigration Appeals that they don't supersede the Supreme Court. But it's been a big, couple of months on these issues about cancellation of removal. And we're going to keep our eyes peeled for what the Supreme Court does with the Barton case that they took cert on. It could be a game changer, and not for the better in the Ninth Circuit if they decide that the 11th Circuit got it right, because we in the Ninth Circuit have the better case law for our clients right now.
Mm-hmm.
But it's to be determined what they'll do with it, and we'll just have to wait and see. But those cases have all been really impactful. The Periera decision last fall, then the Barton decision at the 11th Circuit, the Mendoza decision, Mendoza-Hernandez at the Board of Immigration Appeals, and now the Lorenzo Lopez case out of the Ninth.
It's interesting they're taking on these cases. I mean, it's an important case for like the Supreme Court take on, Ninth Circuit take on, because it's really a battle going on between the branches of government and the people. But at the same time, I know the Supreme Court is hesitant to take on immigration cases in particular. And one thing that was always troublesome is when federal courts get hold of immigration cases, because immigration is so nuanced and so niche, that the decisions that they make it's kind of unskilled. It's not as sophisticated as it should be when I see a lot of cases, because they don't understand the terminology, and they probably, I mean, how could a Supreme Court justice, even Ninth Circuit, as smart as they are, really understand immigration law unless they're practicing it? So even for them, I mean, they have to have staffers that tell them, and that then makes it kind of questionable whether they can make a decision on their own when it's really staffers telling them. But in reality, having been the court systems and myself as an intern and clerk and everyone knows like a lot of times the clerks and staff do make the decisions and write up the decisions. And I think that's what's going to happen. So it's hard to see which direction these things are going to go. But it's good. I mean, these have been good decisions, and I'm glad they're paying attention to them, because it's kind of silly what the DOJ is trying to do or DHS is trying to do in these matters.
Yeah, I mean, it's going to be a continuing battle. The Periera decision last summer not only spawned all of this litigation that we just talked about today involving when a notice to appear triggers the stop time rule, but there was also a series of litigation about whether a notice to appear that was filed without that time and date was really sufficient to initiate removal proceedings, or whether it created a jurisdictional defect. Mm-hmm. By and large, the courts have said it does not. The Seventh Circuit had a decision earlier this week indicating that you might have a claim on that issue, but you would have to raise it at the very beginning of your case and not later on appeal. And as I'm perusing the BIA's website right now while we're having this conversation, I see that they just issued 2 more decisions, a pair of twin decisions today, that basically state that a notice to appear that is missing that information, that you do not have to reopen an in absentia order for a person as long as a hearing notice was later sent to them. So again, I mean, I think this tug of war is going to keep going for a while between the arguments that the immigration bar is coming up with, the way the Board of Immigration Appeals is viewing these things, and the way the circuit courts are. And it wouldn't surprise me, even though the circuit courts have by and large found no jurisdictional defects, the Seventh Circuit said it's not a jurisdictional issue, but that there could be a claims processing issue. If that makes it back up to the Supreme Court too, for them to rule on what other consequences a notice to appear lacking the time and date of the first hearing could have on proceedings. So, and what's funny about this, of course, I mentioned earlier that I've seen a handful of notices to appear since Periera that do in fact have that information on it. And I think it's because there was a little bit of a scare in the government in the immediate aftermath of Periera about whether or not they might have a whole bunch of cases pending with jurisdictional defects. So they started putting placeholder dates on them that that were not real because the Department of Homeland Security did not, in fact, have access to the calendar for the court. And that, of course, created a whole nother set of problems when people were showing up on those days, only to find out they didn't actually have court. And sometimes an actual court hearing had been scheduled that the court staff could give them. Sometimes it hadn't, which meant they just had to wait and hope they were going to get something in the mail to keep them updated about their court hearings. The Periera progeny is going to have a lasting impact on the immigration system for a number of years, not just because the case law keeps changing, but because of these NTAs that are being drafted in funky ways, if you will, and leading to a lot of confusion amongst people about when they really do have to go to court.
You know, it seems like the immigration court system is a slow train wreck or car accident happening in front of our eyes. That it's set to implode. I can't. The system doesn't make any sense. Like with the backlogs, when the government shutdown happened, that mess. Prairie fake dates, having things on the weekend or made up 31st dates for months that don't have 31st dates. It's just like
come to the midnight. Those were good ones too.
Yeah, and it's a theme I've been talking a lot about. Is it further undermines the legitimacy in our system, and especially in the courts. I mean, already due process is a joke in the immigration court system. But as we further undermine due process and the idea that America is a nation of laws, and some say someone breaks the law, okay, that's what we have the court for, so we could sort that out and deal with it. But when that court system is a kangaroo court, and it's, judges, and I've been talking about this a lot, are these real judges or Department of Justice employees, which means there's two prosecutors against one instead of a neutral party. I'm glad the word is kind of getting out. People are talking about this more, and even the judges are frustrated at this point because of the current Justice Department pressure putting on these poor judges, where they're like, a lot of people have mixed opinions about immigration judges. Some of them are nicer, some aren't, or whatever. But at the same time, they're there to do a job. And when they can't even do their job in an impartial way because of things that are forced upon them, or just how the system doesn't make any sense because it's overloaded and not maintained properly. I mean, I don't know what's going to happen, but it seems like a slow descent into hell and destruction. Well, first destruction and then hell in this system. And that's one of the reasons I don't practice it. It's just, I'm like, I can't maintain my sanity if I had to think about this stuff on a repeated basis. I already have issues with USCIS and dealing with that stuff.
Well, I share your frustration with USCIS for sure. You do a lot more USCIS work than I do, but I've certainly experienced some frustrations with even the most basic of administrative tasks there. But you're right. I mean, things at the immigration court are a bit of a mess. And, I have, as a former Department of Justice employee who used to work as a research attorney in the immigration court for the judges, I have a great deal of respect for the difficult jobs that they face, right? Mm-hmm. On one hand, it's an area of law that, as we just discussed, is constantly in changing, right? Constantly in flux. What today's rule could be tomorrow's outdated idea. And they're doing it on a shoestring budget of resources. A federal district court judge on average has 3 law clerks and 1 legal secretary, which I think they have the option of turning it into a 4th law clerk if they prefer. In the immigration court, you have about 1 law clerk shared between 3 to 4 judges in many instances, right? That is
with a caseload, that's probably, I don't know the numbers. I'm assuming the caseload is multiples of what the federal judge has.
Yeah, I'm not sure what the average caseload of a district court judge is, but I'm pretty sure that the average caseload of an immigration judge, at least in Los Angeles, is nearing, if not topping, 2,000 cases. And the last statistics that I read are over 800,000 open immigration court cases.
Yeah. So, whatever you think about the judges, positive or negative, I mean, as human beings, like, it doesn't make sense to put them into that pressure cooker and have them make these decisions. Mistakes are going to happen, and these are people's lives at the end of the day that they have to make decisions on. So I am sensitive to what the judges endure. And I mean, the judges union is trying to push back on this kind of stuff. But funding is an issue. It's a heavily politicized area. It has to be the legislature has to take charge, in my opinion, make these into independent Article 1 courts and then give funding for them so they get done properly. And if the goal is to deport more people, I think if you have a cleaner system, that Trumpian goal would happen. Because all the stuff he's doing right now is causing more, it's a paradox. It causes more of the problem he's trying to prevent, or the issue that he has, he's making more of it the way he's handling things.
Yeah, I mean, it's You're right. The independence of the immigration courts is really a problem. And you're right. The judges union has been very vocal about this. But fundamentally, at the end of the day, the attorney general, who is a political appointee, is the boss of all of the immigration judges. And he has the authority to take cases out of the normal line of, appellate processing and issue decisions as he sees fit, notwithstanding whether or not they conflict with longstanding prior decisions, notwithstanding the impact they may have on tens or hundreds of thousands of open cases. I mean, we saw that a lot when Jeff Sessions was the attorney general, that he was, he issued several major decisions that overturned prior BIA precedent and had an enormous impact on tens of thousands of pending cases, and even threatened to have an impact on tens of thousands of administratively closed cases.
Mm-hmm.
And as so long as you have a political figure who is effectively in charge of all immigration law at the agency level, you're always going to have the suspicion that things are really motivated by politics and not by due process or respect for the law. And I think that's a major problem of the immigration system. And I think the judges would all agree that the system would have more integrity, that they would have, that their decision making would have the appearance of greater integrity if they were not subject to the whims of a political appointee. If they were an independent court, as you say, just like the circuit courts or the district courts are, where the only higher power they have to answer to are the appeals courts or the both agency and federal appeals courts that are above them. But that the agency appeals court also then needs to be independent of the political appointee who is the attorney general.
Yeah. No, one thing that popped in my head when you're referencing, federal district courts and such is up until Trump, and he's been doing like a fantastic job for him, appointing judges in those areas. There's a lot of empty federal judge seats.
Yeah.
And so if it does become Article 1, that's that many more judges that have to be, chosen with the legislator and all that process and stuff. And so it's going to be a really complicated thing to fill up those positions. And then the higher standards requiring federal court is going to change the whole system a lot again. They're going to need more space. I mean, in downtown LA, the one federal, I think you could fit, 6 immigration courts into half a district courtroom. If you go to the federal district courtroom, it's like this empty room with all these chairs and like 2 people in there, and it almost looks like it's an apartment complex in an immigration court in LA that you have like one room stuffed with like 50 people. It's like sardines in front of a judge. That system's going to be probably more costly if they switch to that. But, justice is justice. So be it. We have to, this is America. We have higher standards. So we got to do that. But the practicality of it, just thinking about it, I'm like, well, that's going to create its own level of issues and funding problems.
I mean, it will be a funding issue, but I also think that it is just so important because the gravity of the situation that we're dealing with, right? This is not small claims court. It's not traffic court, right? These are people's lives, and we can't rush them through an under-resourced system if we really care about justice. I'm not saying that everybody will be granted, even with the resources that we would like to have in the system. They won't, but at least we will know that the people whose cases are not being granted were given full and careful consideration and research by qualified, staff attorneys working for the immigration judges, and we're not, the result of a harried, overly stressed adjudicatory process, which I think is a huge problem in the current system.
It's more to me about us and who we are than about them. They say the people that are under scrutiny. It's just, the higher standards we have as America as opposed to other countries who are our rivals or anything. That's why people want to come here, because there is a sense that in America there's justice. There's no government knocking on your door and then doing crazy stuff, taking your property, taking your life, and all that kind of stuff. And frankly, they do it. If you read the news, you see what happens. But it's still supposed to be better than other places, and that's something we can never bring down, and we are. And we always have to, especially attorneys, because that's our battle for due process, whatever side of the spectrum. Even if you're a nice attorney or on the government side or whatever attorney you are, what our job is to do is to uphold justice. That's our oath and the Constitution. So if it needs to be, even for an ICE attorney, that justice requires you to do more work, or you can't win a case, that should be it. It shouldn't be about feeling like you're on the side of the government no matter what. You're on the side of justice, and that's the oath you take as an attorney. Whether you're with ICE, whether you're with a private bar, whether you're pro bono, whether whoever you are, that's the number one standard that plays into it. And even on our side, sometimes some attorneys might feel the need to do some stuff in a case that might not be clean. That always have to remember that no, justice requires you to be above board and transparent, and you can't do that. Even though you have the best interest of your client in mind, it has to be within the bounds of the legal game that we play within the rules. So it's fascinating stuff. I think it's going to something we're going to be talking about for probably years, and probably the rest of our career, probably. But hopefully not. But hopefully.
Periera will follow us into the future.
Yeah, it's like that saying from that. I never watched it, but that show that just ended on HBO, "A Winter is Coming." The Periera is coming. And it's going to be with us.
You're talking about Game of Thrones?
Game of Thrones, that's it. I think I'm the only person in America who didn't watch it. But
well, I guess I won't have to worry about you giving me season 8 spoilers because I haven't watched it.
All I heard is people were disappointed, and I'm like, well, that sucks. Now, I'm not going to watch it if I'm going to be that disappointed at the end.
Well, I'll tell you, I read the books, and I've seen the first 7 seasons, and I thought it was fantastic up to that point. So I'm hoping that everybody's disappointment is overblown when it finally goes.
It might be because it was so highly rated that even if it just goes down a little bit, it's noticeable, even though it's probably better than other shows. But I try to avoid getting involved in television because I get sucked in and watch shows all day. I have a bad habit. Television is like a drug for me. So I'm like, I just got to go cold turkey and not watch anything. Okay. Or else I'm going to be stuck with it. But sorry, we're going off on side.
Not even 90 Day Fiance?
That all, we don't have cable or TV, so if it's on YouTube or something like that, once in a while, my wife will play it and I'll watch it because that's a good show. I gotta say, it's a good show.
I've actually never seen it.
It's funny and it's real too, I think, and it really captures for me like the situation with K1s. It's always a lot of time, interesting couples. Let's put it that way. That go the K1 route instead of the marriage counsel processing route. I get contact, I'm sure you do too, by the organization that shows that wanting couples. I'm like, I can't have my clients go on this show. DHS is watching this too. It's just not a good thing to do.
Nobody's called me, but that's okay because I think I've never filed a K1 in my career.
It's probably for the best. But so I'm like, I can't do that. Who knows what kind of things out of context they'll put on screen that's going to hurt the client's case. So it's like malpractice to recommend your client go on these shows. You
can record it, but you can't show it for 5 years until my client's a citizen.
Yeah, exactly.
All right, John.
Bye-bye.